Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third party spokesperson, sponsors this podcast. I'm Andrew Bichard. Today I read the case Lyons MVP Party versus Electoral Board 945 NE 2D 1175, Illinois Appellate Court, 1st District, 6th Division, 2011. Friends, we're going back to a state that appears to have a lot of third parties, Illinois. Friends, I went to high school in Illinois. Illinois is where my political awareness developed. It's where it started. So anybody out there from Illinois, shout out to Illinois. This case involves the Lyons MVP Party. Like I mentioned on another podcast or two involving Illinois, when I went to the Secretary of State's website in Illinois, I found there were a bunch of third parties I never heard of. They appeared to be local in nature. I never heard of them, but there are so many. In most states, you're lucky to find 6 third parties listed in the Secretary of State's website. But in Illinois, I found tons. Lyons MVP Party appears to be one such party. I've never heard of that party until today. So I ask you, friends, what is this party's platform? Are they progressive in nature? Are they conservative in nature? Anybody out there care to enlighten me? Let's read from the record to find out the predicament this party faced. It says, quote, petitioners in this election case, the Lyons MVP Party and a slate of candidates for village trustee Pedro Castro, Patricia Kruger, and Michael J. Shaikowani appeal an order by the Circuit Court of Cook County affirming the decision of Respondent Lyons, Illinois Municipal Officers Election Board to invalidate nomination petitions filed by them for the April 5th, 2011 Village of Lyons municipal election. The board found the nomination papers invalid under Section 10.5 of the Election Code 10 ILCS 5-10-5, and ordered the petitioners' names not to be printed on the ballot. End quote. So why were our friends at the Lyons MVP Party denied the opportunity to get on the ballot in this election? It happened because of a detail. I've heard third parties talk about how these election boards use every little detail they can find to strike third parties from the ballot. One time, a Reform Party representative told me they denied some petitions because it was, quote, on the wrong way to paper, end quote. In this case, it was another such basis they tried to deny them. Fortunately, the Lyons MVP Party fought back. So let's find out what happened. It says, quote, the nomination petitions signed by the voters state that the candidates are nominated to run as candidates of the MVP Party, a new political party. However, the statements of candidacy filed by the candidates state the word nonpartisan near the top of the form. Respondent Paul Mark Sharori objected to the nomination papers on the ground that the papers did not comply with sections 10-4, 10-5 of the code. End quote. Then it goes on to say how most of the board agreed with Mr. Paul Marchuri because of this. They said this confused the voters, so they needed to get it out. So friends, at this point, what do you think? Do you think our friends have a chance? Therefore, this court looks at past cases where there were disputes of this nature, where there was some mistake made that was unclear. They do mention a case where somebody, it's the case called Clorton versus DuPage County Electoral Board, where somebody filed for a Democrat office, but they were actually a Republican. That's very sneaky of them, if you ask me. Sneaky, sneaky, sneaky. Fortunately, it says in that case, they struck the petition. So, friends, if you ever get your petition struck, take consolation in the fact that sometimes it happens to the Republican Party too. They deserve that. They say this case is different because, quote, in the case at bar, either the candidates were given a form for the statement of candidacy with the label nonpartisan or selected the wrong form. There was no showing here of any fraud, nor did the objector claim fraud, end quote. Thank goodness. They didn't have to fight that battle. It sounds like an honest mistake to me, and that seems to be what the judges believe here. They also note the law did not require these individuals to proclaim the name of their party in the statement of candidacy. They also say, even though they used the wrong form, it didn't have any bearing on the election. The state argued that this caused confusion nonetheless because they were stating in one sense they would be nonpartisan but also a member of the party. Does it really matter to them? Why are they nitpicking over such a detail? What's their motive? They mentioned another case, actually a few cases, where in some cases people were unclear about what they were doing, such as naming the office they were running for, or they slightly named a town wrong. But they said because it was obvious what they were trying to do, it was an issue of confusion. And they apply this to this case. They say there was even one case that was very similar to this, where a nominating petition and their candidacy statement didn't agree, but it was only one position, so there was no reason to be confused. They make a point that I wouldn't have thought of on my own. So this goes to show us that the judges can help us out. I've mentioned that in other cases where sometimes judges see parts that we wouldn't see ourselves. I don't know if the Lyons MVP party thought of that. Maybe they did. If they did, bravo. Maybe you would have thought of it too. So let's read what they thought of. It says, quote, however, language indicating nonpartisan, which is the incorrect language, appeared on the statement of candidacy, not the nominating petition. Thus, the voters signing the nominating petition were able to sign knowing the correct information that the candidates were running as members of the MVP party. This is not a situation where the voters were unable to determine which party the candidates belonged to. That information is clear. Accordingly, there was no basis for confusion, and the candidates should have been permitted to be placed on the ballot. End quote. We're getting up the top of this hill in this case, friends. We're getting to the top. Are we going to get to the top? The absolute top? The peak? Let's find out. What is their ultimate ruling? It says, quote, for the reasons stated above, we reverse the board and the circuit court and order petitioners' names to be placed on the ballot for the election of trustee in Lyons, reversed with instructions. End quote. Lyons MVP party, you won. That's a win for us third parties. I don't know how you got the name Lyons MVP. That's a clever, unique name. We give you credit for that. So thank you for fighting the good fight for our side, for ballot access. Thank you for establishing legal precedent in this published case. in this published case. So let us proceed with this inspiration penetrating us. Long live third parties. Goodbye.